On when you're done,
Just got the one page.
and the yellow light will come on when you have 30 seconds left.
I know, I shouldn't take that, just as he has these issues. Good morning, members. My name's Pat Johnson with Texas Towing Compliance. During the month of November, we took 4,000 calls from consumers across the state on towing issues. I've provided y'all with a list of issues on the major issues that I've seen based on the paperwork and talking to vehicle consumers. Number one is failure to display the BSF employee license when they go to the window. Number two, failure to provide a copy of the non-consent tow fee schedule for the tow company to deliver the vehicle to the BSF. Number three, failure to show proof this notification letter was mailed on a Saturday or Sunday when the second day falls on a Saturday and Sunday or a holiday. Number four, failure to provide the TDLR license number on the vehicle inventory who did the inventory. We're finding out that some of the record drivers are doing the inventories, which is a VSF function, and they do not have a dual license. Failure to provide the name of the person who authorizes the tow. The VSF receipts are still continuing to show the name of the department complex, and the rule specifically says the name of the person. If you do not provide the name of the person, you will pay out in the tow hearing for violation of 2308-455. Failure to release. Another problem we're seeing, the police had to be called a lot lately, is when after they submit payment and they presented all the documents, people do not want to sign the business paperwork. The only form that has to be signed at the BSF is the notarized form. And the reason we tell them that is because identity theft. You already got their personal identifying documents. The signature on the driver's license is so small you cannot use it as a forgery document. But when you sign the paperwork, you give them a fresh signature because of the number of felons working in the BSF. We tell them not to sign it. Another problem we're seeing is the BSF's refusing to provide the insurance information, so when someone wants to file a claim on someone's insurance policy, they want to fill out their business paperwork so they can conduct an investigation. They're required to provide the insurance information to the consumer when he requests it. Also, we're seeing the failure to provide the name of the person, address and phone number, and the rights on the receipts, the tow truck receipts, when a boot fee is charged or when a drop fee is charged in a parking lot. Those fees are contestable under the tow hearings. All these violations, rule violations, which the vehicle owners or operators are instructed to submit a complaint against all four licenses, not just the tow company license or the BSF's license. We want to go after the tow truck operator and the vehicle storage facility employee, because the companies are getting hit with these fines and these violations are being committed by the employees. So they need to be held responsible. And even though the vehicle owner may not file a complaint,
your time's up, so if
just
you'd wrap
one
it up.
last sentence.
Okay.
Just even though the vehicle owner may not file the complaint, when we receive all the documentation and photographs, we're going to submit the complaint on their behalf to ensure compliance of the rules. Thank you.
Thank you. Okay. Charles, are you going to come up on these discussion items? Okay, the first one we have is whether a property owner may move a vehicle from one location to another on the property without towing it to a licensed vehicle storage facility, commonly known in the industry as a relocate, that is done when the property owner is going to do repairs to the parking area or construction or something.
For the record, Charles Johnson, Assistant General Counsel. The issue of the relocates was discussed, I believe, over several meetings of the internal task force. And the conclusions that were drawn as a result of those discussions is that there's nothing in the existing statute or the agency's rules which would permit that, and that it would require specific authority for that to continue to occur without going afoul of the existing statute or rules.
And Charles, we've included that language in the compliance staff report under the internal task force discussion.
I saw that. Okay, are there any questions or discussion on this board? At the very least, I think we need to do an FAQ or something in the tow hookup to
Absolutely.
put the industry on notice that this has been reviewed and, it's not,
Requires
not allowed.
statutory change.
Yeah. So that would be a good topic for that
Yes,
We'll
ma'am.
definitely do that.
publication.
Well, in the interim, this is truly detrimental to the consumer and to, the property owner who is trying to improve their property. I mean, did you look at other statutes that might, like property code or something, Charles? Something in law that might not be in our statute that would help property owners in some way? Because, like I said, this is purely about the consumer and protecting the consumer. I mean, it would be a travesty to have to tow a vehicle off because the lot needs to stripe or make repairs. Particularly whenever, in many, many, many cases, I know in our case, my company, the property owner pays, not the owner. The property owner is the one that pays us to move a vehicle so that they can stripe their lot or make repairs. And we don't want to take it to the storage facility, that's for sure.
There was not a review of the entire set of statutes, and I think that was necessary, and that the authority to tow is in the occupations code. And no one, I guess, takes issue with whether or not there's a convenience or inconvenience, but looking at it clearly from a statutory authority perspective, and recognizing that, and again, without addressing the specific resolution, but looking at it from a purely statutory perspective, it's not clear that the property owner has the right to have the vehicle towed if it was placed there with authority. It was an authorized park, and so whether or not the property owner can tow it is a question.
Well, we're talking about move, not,
Well, move,
No,
tow,
he's saying tow it to, even tow it to the storage
even tow it to
lot.
the storage facility, because the vehicle was parked there properly to begin with. So I mean, that was part of the discussion, but the response I've given you this morning was not to resolve that issue, but just
Sure.
to place a marker there that is an issue that would eventually have to be resolved.
And I want to applaud the staff because the answer was already there.
yes, yeah.
The answer is obviously in the statute.
Yeah.
Bill and I pushed them at least 15 times to look at it as from every angle, and they did.
Yeah.
They really worked on this one, and it's a matter of if you hook the vehicle up, whether you're moving it across the lot or to the backside to achieve a good end of getting the lot striped, it's still towing somebody's vehicle without their permission, and they didn't do anything wrong. And the law does not provide for a person's vehicle to be towed without just cause. And that's what it boils down to. So it's going to require some type of statutory fix to infuse what I think
Yes.
we know is common sense in this moment.
Right.
But it doesn't provide for that vehicle to be moved without that owner's permission or operator's permission. And they've done nothing wrong. And again, we went back and forth with the staff, they'd send up a response, and I'm like, take another look at it, and to their credit, they did, but they're right on this one, and I think we all know that you can't do it. We know why it's being done, but the law does not provide for that.
Well, again, I wonder in the property code if there's something, rights that property owners might have separate and apart from our statute, and, especially if they're bearing the burden of the cost then, you know, it's not to be detrimental to the public in any way. I just wonder if there might be a hook to hang on to till it can be changed statutorily.
If
'Cause
there
that's
is
gonna
a
take
hook
while.
that's out there, we will listen to it.
Okay.
But at this point in time, Charles is right that our
Okay, he's
role is
right,
to
yeah.
interpret our occupations
I
code
understand.
and not find that avenue. But there are associations out, the apartment association is very effective, that if they can find the hook, they will.
We'll ask.
And we'll definitely sit down and talk to them on that.
I had a question. When it comes to parking and it's a paid parking lot, let's say, a vehicle pays for the parking, but they might be blocking somebody in. They might not even be in a spot, but they did pay for their parking. If the parking lot operator, not necessarily like myself, the boot operator, but if the parking lot operator wants to have that towed, is that still against this rule? Is that still?
Do you mean towed to a VSF or
No, just
relocated?
moved, just relocated, so
That's
another
part-
spot on the parking lot.
I think that's part and parcel of the same issue.
So we are within the same realm there, okay.
Well,
Mr. Comfort, did you describe a situation where the vehicle is blocking the flow
Yeah,
of traffic?
that's-
Correct, so it
There's
could
some
just.
language in the statute that deals with that.
You
Now
tow it to the
that-
VSF, though, you don't relocate it.
To the VSF.
That-
It has to be
but
towed to the
It's
VSF.
the same thing.
Yeah.
They
Yeah.
relocate it.
But you can tow it, there's authority to tow that.
We understand we can tow, but a lot of times the parking companies themselves will want to just relocate. Again, it's trying to help out the consumer. They don't want to have to put them out any more than they have to. But yeah, it can be just as simple, not necessarily even a lane, but just blocking somebody in. They didn't pull all the way in. It's on a corner of a lot, and nobody can back out because of that. So,
And without
you know.
erroneously referring to the specific statutory section, there's a provision in the Occupations Code 2303, 2308, which says that if a vehicle is towed, it has to be towed to the VSF unless there's an agreement otherwise. That's the
Period.
provision that applies to both setups.
Gene Forrester here, and Madam Chair, I have a question on the same thing. And it's really just a clarification because I've run into a lot of questions from JPs and tow hearings, and the specific language apartment complex and 2308 253, and then parking facilities are under 2308 254. So whatever you wind up with, I suggest it should be clear it applies to both.
Yeah, if it involves the issue of relocating for any specific reason, I think that section of the Occupations Code which says it has to go to the VSF is applicable. And there's only two places that vehicle can actually be towed to. One is the VSF, the other is by agreement of the parties.
But if it's an FAQ and it says apartment complex, it really applies.
To be
both.
broader, yes, sir.
Yeah, the parking facilities.
Correct.
Thank you for your work, Charles.
Thank you. I guess I'll say put.
Anybody else on this? Okay. Yeah, let's get something and hook up for the next, as soon as possible. Okay, the next item is whether a VSF employee may charge a notary fee for notarizing vehicle release documents. And this came out in a FAQ recently stating that they may not. And I'd always thought that the employee could do this as long as the VSF was not getting the fee. That the employee could do as an independent notary, they keep the fee, and that way the consumer can get their car with convenience and go on down the road. But this is confusing. The FAQ sounds like the employee can't even do it. You can't even have a notary on site collecting fees.
That was the consensus of the task force, yes, ma'am.
And how does that, where is that in statute or rule
In that
that?
the statute specifically says that the VSF is only authorized to charge a fee that is provided in 2308 or 2303. These notary fees are not in any of those two chapters of the Occupations Code.
So even if the money doesn't go to the VSF, if you have an independent notary, work as a VSF employee that does the notarization and keeps the fees, the VSF is not charging the fee. It's not on the receipt. It's not on the credit card. It's a separate fee altogether.
Without taking issue with any of that, again, I reiterate the consensus of the task force is that that fee is not a part of the 2 chapters of the Occupations Code and therefore cannot be charged. If a person does not want to pay that fee, should they're authorized to go elsewhere to have those documents notarized, but the charge is occurring at the VSF, and those fees that collect from the vehicle owner are regulated.
I think we need to send this back for further review, because these folks at midnight, 2 o'clock in the morning, picking up their cars for their brother or sister or whatever, there's nobody around. So they're not going to go anywhere else to get that notarized at that hour of the day. They're looking at another day's storage and another trip. And that's even worse than the relocate issue, to not be able to do that. I mean, that's a big deal.
I think
When
that-
someone's without their car and they can't get it to go to work the next morning, it's bad enough that they're towed. And then you can't, and it's a voluntary thing that people offer. You know, we don't have to do this. A lot of people don't offer it, so they do get another day's storage. But when you can help someone out by having this function at your VSF, and it's going to be very bad not to have that ability to do that.
And I think those concerns are appreciated, and at your request, we will go back and have further discussion on the issue. I'm not sure whether it's going to change the result, but again, out of openness, the discussion will continue, and we'll bring it back to you at the next meeting.
Yeah, I think we have room here. If the VSF doesn't get the money, it's not on the credit card, it's not on the receipt, if it's a separate transaction, I don't see anything in statute that prohibits that.
If you take that argument, you could say that if it's not on the receipt, they could charge any other fees as well. And again, not take issue with you, but
But this fee is not charged. They don't have to pay this fee. I mean, if the owner comes and that's their car, this fee doesn't happen. They don't need a notary. So it's not, this is something, a convenience for someone who is not the owner of the vehicle that's picking it up for someone else. So it's different in that respect, because it's not, you're not saying, I'm charging everybody a notary fee to get their car. It's a voluntary thing. If you want me to notarize it, I'll notarize it for $6, or you can go down and find your own notary and come back. You know, it's not, they don't have to do that to get their car, but they can leave and go get someone else to do it. You see what I'm saying? It's kind of, I don't see throwing in all these fees that you have to do to get your car, but we're not putting it on the receipt. That doesn't.
But again, we will reconsider the issue, but the arguments that you raised, I think, were part of the discussion. So we appreciate the sensitivities and the convenience and all those issues, but it became a question of the application of the statute. And so, as I said, we'll take this back to the task force and reconsider it, and I'll bring you back the second opinion.
Okay, anybody else on the board have any comments or? Okay, let's move on to the last discussion item, whether a law enforcement agency may require VSF to check that the person picking up the vehicle has insurance before releasing the vehicle. This again was on the FAQs that went out recently, and this is an issue for those that do police tows for no insurance, that it's a law enforcement requirement. It's not,
Right.
I mean,
This is the second time that we've looked at this specific issue, and I'll take you back to the first time we looked at it several years ago. There was a bill filed in one of the previous sessions, which would have authorized municipalities to not release vehicle, well, to pass an ordinance to require insurance before the vehicle was released. That bill did not pass.
I thought that was for private VSF,
But
bill that,
the issue being is that there was a bill passed that would have allowed a VSF to hold a vehicle without insurance. The bill did not pass, and so therefore, by statutory construction, is that if the bill doesn't pass, then we can't have an interpretation or a rule to do what that bill itself would have done. in that context, I mean, that's our starting point. And now we go to the existing setup today, is that if a municipality passes an ordinance that requires some document other than the documents that are set out in the statute for release of a vehicle, those requirements are extraneous to the statute and I don't believe are enforceable. And I think that's where the work group ended up at, is that the statute lists specific criteria to obtain the release of a vehicle. And these requirements are in addition to those and therefore not enforceable.
Okay. Number one, I thought municipalities could always be more stringent than state law. You just said the opposite.
Not for the release of a vehicle. There's a list of things that are in the statute. Statutory construction says that when the legislature lists specific criteria for an event to occur, that is to the exclusion of all others. And in this
Even if
instance,
you're a government VSF or a law enforcement?
yes, ma'am. Statutory
For law enforcement?
Statutory construction
Oh,
says
wow.
that a list of items in a statute is to the exclusion of all others, no matter what the source of the others is. And in this instance, the statute sets out what's required in order to obtain release of a vehicle, and our rules are set out to clarify those requirements. And so that list of things is to the exclusion of all others.
Ms.
Madam
Rash?
Chair, first of all, Charles, if we based our decisions on bills that didn't pass, I don't even know how that could even occur. That bill has been introduced every session for the last 6 that I'm aware of. And it doesn't come out of committee because it says that we have to check every single person for their insurance. And I will tell you what, we haven't testified for those bills either because, we want to put that onus on law enforcement that requires it. But at the same hand, the department and these rules are impeding our industry from doing business with law enforcement. Do we want to encourage them that they get their own vehicle storage facility because we cannot do what they're requiring us to do? This is not something that a VSF is just blatantly saying and checking that you have to have insurance. This is in a contract that these VSFs have. And it is in just way above, because in any time the municipality can do what they want in furtherance of or implementation of a state law. It is a state law that you have to have insurance. And if they want to make sure that that person has insurance, whether they want to look at it themselves or let us fax it to them or however they want to do it, then this department cannot stand in the way of a contract that we have with law enforcement, or we're all in trouble, clearly. So I would beg to go back and look at this in that respect, as that law enforcement absolutely has a right to do this. And we're an agent of law enforcement, and the department can rely on, and I thought this question was already answered, that law enforcement is the one that's requiring this to happen. Therefore, we have to abide by what law enforcement tells us to do. Like I said, otherwise, they'll just get their own storage lot and we'll all be out of business. Sorry.
That's okay. But with all due respect, I think we're kind of back where we started in that it all stems from the statute.
Okay, Charles?
Yes, sir.
I think we can do some study of this, and I can ask for an Attorney General's opinion of it.
That wouldn't hurt my feelings. We need to answer. This is a huge issue, Bill. This is impeding our ability to do business with law enforcement. So
Well,
it's a huge
All
issue.
right, what would help is if law enforcement would request of us that
Okay.
we ask for an Attorney General's opinion, and we will do that, and then we can move forward with it. And then it will be what it is.
Okay. And then,
Do we have any comments from our law enforcement members here?
Yeah, I request an attorney general.
Me too.
Because
Okay, there you go.
This is a big issue.
it's a
because
big issue.
we're enabling people to get out on the roads without insurance, and it's costing people that have insurance thousands of dollars every year. It's something that doesn't need to be happening.
Well, and if they're towed for not having insurance, and then you let them out without proof that they got it, that's just crazy.
Exactly.
I mean, that's just beyond the
I
pale.
think-
I mean,
I think there are medical reference documents that would not define that as crazy. I think they would just define it as what it is. However, I think we'll go with Bill's option of looking at AG's opinion, and we'll figure it out, because this is one of those moments of conflict where there's a local ordinance and a need, and it absolutely makes sense. Somebody goes in because they don't have X. But there's also a state statute that says, here are the only things you need to release a vehicle. And it's Y. And we can figure that out. And we have no dog in the hunt and all those other country cliche things that mean the same thing.
But
And we'll just
Brian,
answer-
we have added, this board has added other documents to the list to get your vehicle.
Have we
So
added
what is
insurance?
impeding, can we? I'm asking you, why can't we?
Well, no, I'm
We've
asking
added
you.
other things.
I'm asking you
Yes,
because
we
I'm going to
could.
ping pong it back on you, because you clearly said earlier that you have testified against doing this. And you wouldn't
I
want to do
have-
that as a rule for everybody.
Because law enforcement is requiring it, not that we
I
are,
understand.
we're doing it as an agent for law enforcement, which gives us cover under their immunity. You see, that's why it has to be done through contract with law enforcement. And we agree with that. What we don't agree with is that VSFs are required to check
Become the agents
everybody's
to find out
insurance that
everybody's insurance.
drives up in the driveway.
I
That's a
understand.
whole different situation.
So let's go with the AG's opinion. Can we do that?
We can, but I don't understand why we can't add a document that if law enforcement requires a VSF to receive proof of insurance, under that circumstance, that law enforcement is the one that has a contract. Charles, are you taking notes? Then why can't we add it to the list?
We got
Let
him on
me
the
answer that.
AG's. We got him on the
Let me
AG's
answer that.
opinion.
Okay.
If I rush out and say, all right, we're going to do that, fiat,
Okay,
and the Attorney General says, whoa, Mr. Kuntz, you never had authority to do that. That doesn't go well as a headline in the paper. And other agencies have been slammed recently for going beyond what their statutory authorities were. We're going to follow through in an orderly manner. We'll ask for an Attorney General's opinion, and we will solve the issue. If the Attorney General says we don't have the authority, then what has to happen is we have to get a bill in to make that available.
I understand that, but at the same hand, we don't ask the Attorney General every time we add another document to who's the owner, who's this, who's that, in our rules. We don't. So I don't see why that this would be different, since, it's something that is a problem and is something that's, law enforcement has the right to do. Clearly, they have the right to do it. So I don't understand why, since law enforcement in statute has the right to do it, that there couldn't be a form that is used for that purpose. You see what I mean?
I understand what
I
you're
understand
saying.
that you don't see that.
We'll ask for an
But
Attorney
we're
General.
going to get there. We're going to get there.
All
I
right.
clearly did.
Okay, I'm with, if that's what we need, we'll fix it in statute.
Mr. Kuntz is a risk taker, and I go
I
way
know
out
you
on the
are.
limb quite often.
I know you do.
You're asking me to go a little further than I'm comfortable
All
on.
right,
So we're going
I
to
appreciate
step back
that.
and ask for the opinion.
So who is are we gonna get it from?
Vince has requested an AG
RG.
opinion
Consider it done.
through TDLR,
Okay.
so
Okay.
they're going to have that out next week.
It may be a Christmas present. It may be.
Okay. Any other comments or any discussion on that? Okay.
Can we help with that, drafting?
Any assistance you want to provide
Okay.
as you can.
Okay.
We're not going to have you at the table writing it.
I understand.
And you're not going to get final blessing
I
on it. But if
understand.
there's language you want to send to us,
Yeah, okay.
question-wise, absolutely.
Okay. There you
And
go.
also know that when there's an Attorney General opinion, that you can also submit your comments to
Yes.
that opinion there. So you're
Yes.
not going to be out of the process, but you're not going to be driving the
Yes,
process.
and we'll make sure other law enforcement